paragraph 6.2, my lord, we say, before the commencement of the Hearsay Act of 1988, an accused extrajudicial statement were admissible as an exception to the hearsay rule against a co-accused to prove the conspiracy or common purpose. And we say the exception fell under the vicarious admissions or the executive statements category. Now we come to the quotations that I said Dutoy mentioned in my previous address, that Dutoy at page 24 to page 50 submits as follows. For the following reasons, the common law exception have been abolished. A, Section 216 of the Criminal Procedure Act, which ensured their survival by applying the English common law, has been repealed by Section 9 of the Law of Evidence Amendment Act. Paragraph B, the specific treatment of hearsay in Section 3 makes it clear that hearsay cannot be regarded as a case not expressly provided for.
Anytime I hear the word hearsay evidence, to me it's equal to Zungunaiser, because Zungunaiser's entire testimony is based on him and what he says happened. But there's no corroboration. So, and then I ask myself, how does my Lord listen to Zungu's statement and go, yeah, that's the one. These guys are going down. They're going down for the unaliving of SENZO MEYIWA. Because here's the thing. It would be one thing if Zungu's statement said, and then I was in the car with them, and then I saw them go into Kelly Khumalo's mother's house. So it moves it from hearsay evidence to he was there. He's now an eyewitness, except he was not inside Pagati within Kelly Khumalo's mother's house. Therefore, it still remains hearsay evidence. You see, it's all around. No matter which way you try to make it look nice and cute with Zungunaiser's statement, it is absolute hearsay. And for me, outside looking in, I don't understand why my Lord, and Baloyi included, have decided that Zungunaiser's statement is the hill they are willing to die on. And then in light of all recent events, the fact that Shadrach Severe was inside Pagati within the interview when he was not even a SAPS employee at the time, when Zungunaiser was being interviewed, for me, everything just screams red flags all around. But you know what? Let's continue listening on and hear where Ramosepele goes, because he is going to land his plane.
For the purposes of the residuary provision, Section 225 of the Criminal Procedure has, in any event, expressly repealed, has been repealed by Section 9 of the new Act. And C, the Supreme Court of Appeal held that it was unnecessary for it to determine whether at the trial court, as the trial court has held, the hearsay evidence in question could be received under the common law exception, in this case as an executive statement in furtherance of a common purpose, since, and we quote, the inception is not regulated by Section 3 of the Evidence Act of 1988. And at page 24 to 74, Dutoy deals with co-conspirators, which he says these are special cases. He says, Dutoy, the learned author, that our law has adopted the English rule that a statement made by A is admissible against B if A and B were associated in the commission of a crime, and the statement was made in furtherance of their common purpose. And he also cites with approval Mayet and French Beitach on that matter. Sorry, my lord.
French Beitach. Do you know French Beitach?
Sorry, my lord.
Have you heard of him?
French Beitach? I haven't, my lord.
You've heard of Trevor Huddleston?
The Reverend? Yes.
Very please. Trevor Huddleston, that's the Anglican bishop in South Africa. And he was a very active liberal prince and priest. They arrested him for committing what the old regime used to call terrorism act. Collected money and gave it to Nkonto Wesizwe to use to buy bombs and blah, 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 blah.
Okay.
French Beitach.
So he was charged.
Surprised, Mr. Baloyi.
No, listening with keen interest.
Oh, I see, okay.
So he was charged under the suppression act?
Yeah, he was charged, the first priest to be charged under the suppression of communism.
Yes.
Right.
I can already see you typing there. And you know what? Continue. Because I was also listening with keen interest, like Advocate George Baloyi, who has suddenly taken a Friday off, which has been satisfactory for us members of the public jury, and we are indebted to the court. But what on earth just happened? So Rams is in the middle of giving his heads of arguments. In case you didn't catch part 1, this is part 2. Rams is giving heads of arguments as to why Baloyi cannot and should not cross-examine Umuzi using Ubongani Ntanzi's confessions. Absolute hogwash, thumb-sucking. The state has no strategy. But anyway, I digress. So my lord right now, in the middle of heads of arguments, suddenly decides this is a great opportunity for him to give a history lesson. I thought, okay, let's listen. This is going to take us somewhere. It's going to further the common purpose agenda. It's going to further the heads of argument. He's contributing to the conversation. No, he's talking for the sake of talking. Has no relevance, does not assist in the heads of argument in any way. He left me just shocked. What was that? Was it a distraction? Was he trying to confuse Ramosepele? Or was he just purely trying to show his, I don't know, what he knows about the name that Ramosepele mentioned? Absolutely incredible. And I doubt that Ramosepele mentioned it with reference to whatever they were charged for. I mean, it's a good thing, guys. But let's continue listening on. Yeah, let's continue listening on. I know this deserves patience, guys. And I think Ramosepele deserves us also listening to him. I did see some comments. Why is he stuttering? And I said to myself, there's nothing new that Rams is doing here. This trial has been going on. We're counting 3 years, okay? Possibly headed for 6 at this rate. But there's nothing new that Rams has been doing. And no, I don't know who. That's another comment. I don't know who the lady is behind him. Clearly, she doesn't want to be known. Clearly, she said, I'm going to put on a jacket, a mask, and a hat. No one is going to be able to recognize me. And you know what? I respect that. as an anonymous YouTube channel host. But yeah, just basically, I respect her privacy. Do you know how much I had to resist posting Muzi's mother whenever I do Muzi's videos or when he talks about his mother? I do have her picture, and I had to resist. I have to resist because I feel it's not fair, because, you know, the focus here is Umuzi and not shining a spotlight on the mother. You get what I mean? So I'm just that kind of person. Yeah, so Rams, that's Rams' style. It is what it is. And I'll talk about the next part in the next video. Let's continue on this part, because I know you want me to get to the next part, but we do it step by step on this channel, okay? We don't skip a process. We go step by step, because that's how we build the momentum. Yeah. Let's get into it.
Now, as we're continuing with the conspiracy, I'm leaving what the learned author Ridicules says. And these are not contained, my lord, in the heads that I've submitted. So I'll submit from the bar, my lord.
Okay, fine.
We say, my lord, in a case of more than one accused acting with a common purpose, each is a conspirator liable under the criminal law for the acts of every other conspirator done in pursuance of the conspiracy. We've already quoted, referred to Mayet, the 1957 case.
All right.
And we said that the reception of such evidence is, I've already referred to this one, and I've already referred to the American case. And we say, my lord, that a statement made by an accused which falls short of a confession but amounts to an admission or other statement by the accused concerning his co-conspirators is admissible against the latter, provided that it was made in furtherance of a common purpose. Now, the issue that I want to touch on, that's why I refer to this document, my lord, it's what Advocate Baloyi now says, that if the executive statement exception is not applicable, the alternative is that the Hearsay Evidence Act must apply, so that Exhibit JJ and the other exhibit, which are statements of alleged law of Mr. Ntanzi, must apply to the co-accused. And we say, my lord, the question, therefore, is whether the Law of Evidence Amendment Act allowed the introduction of such statement and whether it is constitutionally sound. If so, a further question arises regarding whether the admissibility of such statement is to be determined. Firstly, we say, my lord, the Law of Evidence Act, the Hearsay Act, did not in its terms purport to change the substantive rules of relevance. And we say, my lord, that the Ndovu case that we cited, which was disproved by Litako, concerned itself exclusively with the application of the Hearsay Evidence Act and found that there were sufficient extraneous factors or evidence to ensure reliability of the extracurricular statement. The court in Ndlovu was not asked to consider whether the Law of Evidence Act expressly or by necessary implication extended the rule of reliability, which excluded any admission made by one conspirator against the other beyond the case where the statement was made in furtherance of a common purpose. Now we deal with what Mr. Baloyi seeks to do, that is to be allowed to cross-examine Mr. Sibiya on the evidence on the alleged statements made by Mr. Ntanzi. My lord, I must say that I was taken by surprise yesterday when Mr. Baloyi stood up and said he wanted to...
Who's that?
When my learned colleague, Mr. Baloyi, said
Okay.
he wanted to refer statement to Mr. Sibiya, which is a statement allegedly made by Mr. Ntanzi. And he wanted to cross-examine him on that because, my lord, we've had a trial within a trial in this matter. And at the trial within a trial, in respect of Mr. Sibiya in particular, when that statement was introduced, the state indicated that we are introducing this statement so that it is binding against the maker. At no stage where the other co-accused recognized to say, should the court admit this statement as evidence, then the rest of you, this statement is going to be applicable to you. Then it will give the other co-accused the chance either to challenge or to acquiesce with the statements made by Mr. Ntanzi.
4:10. Bam! In the hour.
Now, to come up in cross-examination and to say, now that the statements are admissible, I'm going to refer you to this statement to bind you and to bind the other co-accused because this is an executive statement. And by the way, my lord, I submit without contradiction as well, that this is not an executive statement, and I'll show why I say that this is not an executive, those are not executive statements. And I'm also not going to give them a classification to say what they are, because the court has not indicated yet whether these are confessions or admissions. So I'm not going to be brave to say this is a confession, this is an admission.
I don't get into trouble. I cause it. Yeah, I take a decision that will cause trouble now.
Now, to use the civil term, my lord, we say, at the time when the state says, I'm going to introduce, for example, JJ to bind you, Mr. Ntanzi, the term in civil law to say there was no lease between lease, not rental agreement, LIS, to say, Mr. Ntanzi, once your statement is admitted, I'm going to use it against Mr. Sibiya. I'm going to use it against Mr. Mngube, Mr. Mapisa, Mr. Ntuli, so that their lawyers could take the necessary legal routes to protect their clients' rights regarding those statements, my lord. And with VEV, my lord, Kappa versus S is not applicable here because it puts a certain obstacle to the state to the admission of this hearsay evidence. Kappa says, before the close of the state's case, the state must make an application to court, which application will be debated by the state and ourselves, and the court will make a ruling to say, I want to make an application that this hearsay evidence and expounds that hearsay evidence clearly to be admitted against the accused before court. That was never done. The bus has already passed. Now, the submissions that we are making, my lord, to say that this application by the state must fail are the following, and I'm reading now from paragraph 7 of our heads of argument. We state, my lord, that from the principle enunciated in our arguments today, it is vividly clear that Exhibit JJ and whatever extracurricular statement that the state wants to cross-examine Mr. Sibia on were made long after the offenses were committed. And we state, my lord, at the time the statements were made or allegedly made, the objectives of the alleged conspiracy as submitted by the state were no longer capable of being pursued. We submit, my lord, that such a statement or such statements are narrative statements because they are narrating past events after arrest. Because once we apply the Krulovich Wung Song, which say, and also Nkosi Mhlongo, which say, after arrest, any statement made is not an executive statement, but a narrative statement. And we say in this case, my lord, JJ and HHFF, whatever they want to introduce, my lord, and cross-examine on cannot be allowed because these are narrative statements which serve, if they indeed were made by Mr. Ntanzi and Mr. Sibia, to incriminate the makers themselves, but not their co-accused. And I want to state, my lord, and I'll just briefly, as an anecdote, stop here. I want to be like Mr. Munisi, to say, if I say the statement made by Mr. Ntanzi, I'm in no way saying he made it. I'm saying in the context of this argument, because tomorrow I know it will be quoted to say, during argument on the 13th of 2000, Mr. Ramosepele stood here and said, you made a statement. So I don't want, on the right-hand side, when arguments come later, Mr. Ntanzi is held to the contents of the argument that I'm making specifically for this interlocutory application.
So I'm going to admit that when Ramosepele was still alive, I would literally skip the days when Ramosepele, okay, I'm going to raise my hand, okay? I would skip the days because I never understood his style. But one thing I learned in hindsight is that you have to be patient with Ramosepele. He has a style that he uses. He wants all the T's and I crossed. He wants to read everything. He will never just present off the bar, which he did, but for a few moments. And then he brings the heat. He doesn't start with the heat because Ramosepele is that man. I believe, okay, he holds my lord in high regard, and I don't think it's from just my lord. I think it's all judges, and it's the profession and the oaths and the dun-dunnies that he's taken as a learned colleague. So he's very mindful with how to handle things. So with his style, you'll see that he did a slow build-up, okay, literally a good 40 minutes. But now he's here, where he really needs to be, where we really needed him to start and say, listen, I was taken a hold back when Baloyi said that he wants to cross-examine Mzansi Sibia with Bongani Ntanzi's statement. And he's like, how is this even possible? Like, what is Baloyi up to? And then now he's putting it on the record that I see you, Baloyi, and I know your tactics. You have a tendency of saying, he said, she said, and taking things out of context. So I want to make sure the record states right here, right now, that I am saying this for this purpose. I am not saying Bongani Ntanzi made his statement because I know how Baloyi operates. Sneaky, sneaky man. And then he says to my lord, now you see, this is where he's packing the heat, and he says, this application by the state must fail. And the state never did an application for this hearsay evidence to be admitted. So that buzz has already passed. Do not play with Ramosepele, okay? One thing I've learned about him, be patient with him. He gets to where he needs to be. I just think that people are just used to drama delivery right away, and then that makes it a valid delivery. No, I think his style, I don't have a problem with his style. It just took me a while to warm up to it, because you all guys know I love drama, okay? I love drama. So He says that the statements that Bongani Ntanzi made, including Mzansi as well, they were made many years after the unaliving of SENZO MEYIWA, which is true. By many years, we're talking 6 good years later. And I think that's a brilliant point, because how do we know they actually remember? And that also includes Zunguniza's statement as well. So, you know, what is good for the goose is definitely good for the gander, okay? And then he says, the purpose of someone who has been arrested and suddenly is giving statements, those are not even confessions, those are narrative statements. They're done after arrest, and they serve to incriminate the person who is giving the statement. But let's continue listening on, because I'm enjoying this portion. Here goes.
And then I'm called never ever, everything never ever. And then paragraph 7.2, my lord, of our heads, we say we submit that to cross-examine Mr. Sibia on the statements that they want to introduce. Does not fall within the exception, because the co-accused at the time of the trial within the trial, or even in the versions presented by their respective counsels, have never by word or conduct accepted the truthfulness of what's contained in the statements that the state want to adduce and to cross-examine Mr. Sibia or any other witness on. Paragraph 7.3, we submit, my lord, that the conspiracy on or common purpose ends upon the completion of a crime, arrest, abandonment of the conspiracy, or separation of the co-conspirators. And any statement that is made thereafter, my lord, is detached. (7.4), as I alluded earlier to say, executive statements are made in furtherance of a crime. For example, when somebody says we are together, say hide the weapon. We say, my lord, that confessions are made to explain or to justify past acts. They do not advance the common purpose. And we say further, my lord, that the common purpose exception should not only be applied, and specifically for matters that are done or said in the ongoing conspiracy, common purpose. They cannot be admitted against the co-accused under any guise, be it under Section 219, under the Hearsay Act, or under common law. Finally, my lord, we say that executive statements are not even made to police officers. Executive statements are made to co-conspirators. And for that, for those reasons, my lord, I say the application by the state stands to fail, as the court places.
Okay. Sorry, what's the time now?
11:25, my lord.
Yeah, okay, let's adjourn it.
So in the comment section down below, let me know your thoughts. How did Attorney Ramosepele do with regards with his heads of arguments about his very own client? I think, and I appreciate that he took time. He took about 45 minutes, which is 3 times more than Mzansi Unfiltered, because it is his client's statement that is on the line. I think he did a phenomenal job representing Bongani Ntanzi and ensuring to detach him from, he said, even if, let's just go hypothetically in an isolated incident, that Bongani Ntanzi actually did give this confession, it cannot be used to incriminate the others, okay, the co-accused. And I thought that was quite noble, and to ensure that Baloyi'S attempt is curdled right there and there, okay, crippled immediately, so that Baloyi doesn't have any future prospects of trying to use the statement again with accused number 3456. 3456 is not yet in the court, okay, but their J50 warrant of arrest is still, has been issued by Brigadier Bongani Nicholas Kininda. If you know who accused number 6 is, drop it in the comment section down below. But I'm gonna end this video right here. I don't want to make it too long, because I know you guys want us to jump into okay, so we're gonna do his video, then we're also gonna do Shaolalo's video. So make sure you hit that subscription button, turn on notifications. I'll be dropping them throughout the day. I think I owe a couple of other videos as well, so I'll be sprinkling them throughout the weekend. I'll catch you on the next one. Bye.